how does an impaired driving trial work? I want to talk about the typical process of how your day would proceed if you're charged with impaired driving, your case is set for trial, say today. So what'll happen, your case is set from say 10 till 4:30, maybe even 5 it might run to. First thing in the morning, you'll plead not guilty. The clerk will read you the charges, and you'll plead not guilty. Now, the Crown Attorney, as the prosecutor, they're responsible for presenting the case. So what will they do? Well, let's say there's a civilian witness who saw you get in a car accident. So that civilian is going to testify first. The Crown is going to ask them examination in chief questions. That's called examination in chief. Open-ended questions which don't suggest the answer. In other words, who, what, where, when, why type questions. As a defense lawyer, I'm then going to cross-examine using leading questions which typically suggest the answers. I'm going to be trying to challenge their credibility, their reliability, their accuracy, any motives to lie that they might have to weaken their evidence effectively, okay? Now that process goes on, and after my cross-examination, the Crown may apply to re-examine them to clarify anything. So if there's something that needs to be clarified that the Crown couldn't have anticipated a chief and defense counsel raised, which is new. Now, typically, maybe the next officer, person that testifies will be the arresting officer who attended the scene, who arrested you. Again, same procedure, examination in chief by the Crown, cross-examination by me, re-examination by the Crown. Sometimes there's 2 police officers called. One of the most important witnesses is then the breath technician. That's the person who took the 2 breath samples and toxicological breath samples. And that officer is going to be examined in chief, go through all the checklists and procedures of what they did. As defense counsel, you're then going to cross-examine them using leading questions to try and show mistakes, poke holes in their testimony, challenge their credibility and reliability with a view to showing that there was a fatal error or mistake made. Now, at that point, that really concludes the case. Well, I shouldn't say that. It doesn't conclude the case because now you have a decision to make. That concludes the Crown's case, I should say. Now you have a decision to make. Should you call your client to testify? Every case is different, but in impaired driving cases and over 80 cases, sometimes you call your client to testify, sometimes you don't. I won't get into when and why because that's a topic for another video. It's a very delicate decision. You have to decide whether there's reasonable doubt, enough reasonable doubt that you've raised during your cross-examination or even during the examination chief by the Crown that raises a reasonable doubt. And you make that decision with your client. It's the client's decision, you give them advice, but you might call the client. So if you do call the client again, we're going to be calling you, I'm going to be calling you examination chief, the Crown cross-examines, I may re-examine you. Now we're into final closing argument, final submissions. Because if I called evidence, I have to go first as the defense counsel, and I make my submissions. They might be 30, they might be 60 minutes, somewhere in between. Crown does the same thing, summing up the evidence, saying there's no reasonable doubt. I'm pointing out the log, any case briefs, all that sort of thing. And after the Crown finishes their submissions, I have a right to reply to any new matters that arose that the Crown brought that I couldn't have anticipated. And then the judge will make a decision. Typically, they don't make a decision that day that the judgment is called. They'll put it over for another day. Now, conversely, if I didn't call evidence, the Crown's required to do their closing submissions first, followed by defense counsel. So that's, in a nutshell, how a simplified version of a impaired driving trial works. Very quickly, a complicating factor is when you file a charter application. Now, a charter application is really what's called a pretrial application, but typically they're heard on the same day as the trial. There's different types, but suffice to say, a charter application is designed by the defense counsel to try and exclude evidence. In other words, throw out breath samples or throw out statements. Sometimes that can be done within the context of the trial itself, which is called a blended voir dire. That's a Latin term, voir dire. Or sometimes it's done before the trial starts as a separate pretrial charter application. For example, rights to counsel applications are sometimes begun at the beginning of the day. And that may end the case. If you win it, we may not even need to get into the trial because the Crown, that'll throw out the over 80. Maybe the Crown, if there's no impaired, that the case is over. If there's an impaired, the Crown might think it's weak and offer a careless, or you continue on to the main trial proper, okay? Now, If it's a reasonable probable grounds application, that's really blended within the trial. So that's just a bit of a complicating factor. Now, DUI trials, impaired driving trials, I mean, with charter applications, sometimes it's difficult to finish one day. Sometimes they're set for a day and a half or two. If there's no charter application and not a lot of witnesses, we can often finish in one full day. So there it is. There's your trial process for your typical impaired driving with a charter application and without a charter application. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.